Hello everybody, and thanks for joining us for the second in our current series of property disputes webinars. I'm joined again today by my colleague Stephanie Hepburn, and we're going to be looking today at recent developments in relation to dilapidations. There have been a few significant cases in the last couple of years involving dilapidations. We're going to look at three from 2015, Mapley acquisition against City of Edinburgh Council, ATSIP against Inside Travel Services, and PDPF GP against Santander. Mapley and ATSIP, there were a couple of issues in dispute in both those cases. The significant issue was the question of whether the landlord was entitled to payment of the total of the scheduled dilapidations or whether landlord's entitlement suffered. But there are also issues around the interpretation of the tenant's repaying obligations in those cases. PDPF dealt with an issue in relation to timing of notice to reinstate. But before we come on to talk about those 2015 cases, I'm going to look at Grove Investments against Cape Building Products, which is actually a decision from 2014, but it very much set the context for the issue of contractual payment or damages, which followed in Mapley and ATSIP. So Grove Investments was a Scottish Appeal Court decision, an inner house decision issued in May 2014, and the issue was that question of whether the landlord was entitled to payment of the total value of the schedule of dilapidations, regardless of whether it intended to carry out the works, or whether the landlord's claim was restricted to damages from losses suffered. The crucial wording is in bold on the slide there. It was the tenant's obligation to pay to the landlords the total value of the schedule of dilapidations prepared by the landlords. Now, the case is significant because the court, before coming on to decide that issue, the court looked at the general approach to interpretation of contracts in light of recent case law, some of which, incidentally, we'll be looking at the next webinar in our series. And two principles which were of importance in this case. The first is that in terms of the general approach, the contract had to be interpreted in context and in accordance with the purposes that it was intended to achieve. And where a particular provision was capable of having more than one meaning, then the court had to adopt the meaning that best accorded with commercial common sense. Now, in this case, the court concluded that both parties' interpretations were possible, so it had to decide which best accorded with commercial common sense. And it ultimately concluded that the tenant's interpretation was preferred. The landlord's claim was restricted to damages for losses suffered, and the landlord couldn't simply claim the total amount that was brought out in the schedule of dilapidations, regardless of whether the works would actually be carried out. Why was that? Well, there were broadly four reasons for the court's decision. The first was that the court found that the function of the clause was to provide the landlord with rights in respect of the breach of contract, and the most natural way of providing a remedy was to compensate the landlord for the losses suffered as a result of the breach. That pointed towards the tenant's interpretation as being the commercially sensible interpretation. Also, the court found that where the landlord intended to reinstate the premises in full, then the tenant's interpretation provided full recovery for the costs of reinstatement. But where the landlord did not intend to reinstate in full, the landlord's interpretation might result in recovery of more than actual loss, so that the level of recovery might be arbitrary or disproportionate. And the court concluded that was contrary to commercial common sense. The court also found that the tenant's interpretation provided full compensation to the landlord for loss ultimately suffered, and again, that was found to be in accordance with commercial common sense. Now, as I mentioned, this decision was issued in May 2014. In September that year, the decision at first instance in ATSIP against Inside Travel Services was issued, and whilst it dealt with different lease wording, the result was very much in line with and in light of the decision in Grove. But that decision in ATSIP has been overturned on appeal, and we're going to look at that later in the webinar. But in March 2015, the decision in Mapley was issued, and Stephanie is now going to look at that.
Thanks, Dan. Well, as Dan mentioned, the main issue in this case was whether on a proper construction of the lease, the landlord was entitled to a payment equal to the cost of putting the premises back into the relevant state of repair, no matter whether it actually intends to carry out the work or not. The relevant clause is on the lease, and again, the relevant bit is highlighted in bold, and it says that the tenant shall pay to the landlord such reasonable sum as shall be certified by the landlord's surveyors as being equal to the cost of carrying out such work. The tenant contended that on a proper interpretation of the lease, this clause was a damages provision that allows the landlord to claim damages for breach of contract, but crucially only if the landlord proves it suffered a loss, and that it doesn't entitle the landlord to payment where it hasn't undertake the works. The landlord, Mapley, contended that the clause was a payment provision which overrides any claim for damages for breach of contract. They said the landlord was entitled to payment of the cost of putting the premises into the relevant state of repair, regardless of whether it was going to carry out the works or not. They said that the provision was additional to the right to claim damages under the common law, and argued that it didn't matter whether the works were going to be carried out or not, and there was no need for them to prove they had suffered a loss. Lord Doherty accepted the landlord's interpretation was perhaps the more natural reading of the provision, but his view was the clause was ambiguous and both parties' interpretations were possible. And as we've discussed in previous webinars, where a clause has ambiguity, the courts will favour the interpretation that most accords with commercial common sense. The judge applied various principles and also drew on what the court said in Grove, which Dan mentioned a second ago. And they concluded that the tenant's construction was to be preferred and the clause was a damages provision. There were four main reasons for this. The first is our old favourite, commercial common sense. The court said the tenant's interpretation was more in keeping with commercial common sense and the commercial purpose of the lease. The court also said the tenant's interpretation was more akin to the remedy that the common law would provide, which would not enable the landlord to recover notional costs, which it hasn't and will not incur. And the judge was of the view that the landlord's construction would be a radical departure from the landlord's entitlement at common law, and that such a departure would have to be clearly indicated. The fundamental purpose of the lease was looked at, and the court also said the tenant's interpretation was less likely to produce a result which was objectively excessive or disproportionate, whereas the landlord's interpretation may result in a level of recovery which was unrelated to any loss actually sustained. And as Dan said, this case was before the appeal court in at SIP, but at the time highlighted the trend of the courts being quite willing to interpret provisions in relation to dilapidations and recovery of sums in lieu of the tenant carrying out the works, so as to accord with the common law principle of damages, i.e. recovery of actual loss, but which was restricted to the works which the landlord actually intends to carry out or has actually carried out. That wasn't the only issue in Mapley, and Dan is now going to consider the second issue.
The other issue that was in dispute was the interpretation of the tenant's obligations in relation to replacement of plant and machinery. It was an £8 million claim, and approximately £3 million of the claim represented a claim by the landlord for the cost of replacement of plant and equipment. Now, the relevant clause is up on the screen there. There are essentially two parts to it. The first part is an obligation to renew and replace any of the landlord's fixtures and fittings, and the aforementioned items of plant and equipment. That's a reference to plant and equipment in the premises from time to time, which shall be missing, broken, worn, damaged, destroyed, with others of a similar character, condition and quality. And then the second part of the clause, without prejudice to the foregoing generality, to renew and replace the items which were present in the premises at the date of entry, with others of a character, condition and quality, which at the determination hereof are the modern equivalents of those provided at the date of entry. The date of entry, incidentally, was, I think, 1994. So, what did that clause oblige the tenant to do? Were they obliged to replace all items of plant and equipment that were present at the date of entry with modern equivalents, regardless of their condition? That was what the landlord was arguing. Or was their obligation restricted to replacement of items that were missing, broken, worn, damaged or destroyed at lease expiry? Well, again, similar to the issue about payment or damages, the court concluded that both interpretations were possible, so it then became a question of determining what was the most commercially sensible interpretation, and again, the tenant's interpretation was preferred. It was an obligation to replace items that were missing, broken, worn, damaged or destroyed at lease expiry. And the reasoning was very much similar to the reasoning in relation to the payment or damages issue. The tenant's interpretation was more in keeping with the fundamental purposes of the lease, and in that regard, you know, the court determined was the purpose in question here was to hand back premises which could be relet. The landlord's interpretation would have excessive and disproportionate consequences because the tenant would be obliged to replace all of the plant and equipment that had been there at the date of entry, regardless of its condition. The tenant's interpretation was, again, more akin to the remedy which the common law would provide, which again, the court concluded was a factor that pointed in favour of that interpretation being the commercially sensible one. And so ultimately, you know, all of those factors, the court concluded, meant that the tenant's interpretation was the one that was more in accordance with commercial common sense. Now, moving away from issues of interpretation of repairing obligations and interpretation of payment or damages clauses, Stephanie is now going to look at PDPF against Santander, which dealt with the issue of notice to reinstate.
Well, PDPF are the landlords of premises at South Kyle Business Park in Edinburgh, and Santander was the former tenant of the property. And the lease had various provisions which set out the parties' obligations at termination of the lease. The key 5 are on the slide there. The main ones for present purposes are paragraph 3, which states that the tenant is obliged to keep the premises in good and substantial repair. Paragraph 8, the tenant is obliged to carry out repair works on 3 months' notice, failing which the landlord has the right to enter the premises and carry out the works itself. And paragraph 28, which is the last one on the slide there, at the end of the lease, tenant is obliged to leave the premises in good condition and repair, and secondly, to replace the floor coverings at the request of the landlord. Alterations had been carried out, and the licences for works provided that on termination of the lease, the landlord could require the tenants to remove the alterations and reinstate the premises. Santander served a notice to quit on PDPF in August 2013 to bring the lease to an end on 25th November 2013, and PDPF served a dilapidation schedule on Santander 2 weeks before the lease expiry. The dilapse schedule was served in terms of paragraph 8, and the letter accompanying the schedule made it quite clear that paragraph 8 was being relied on. The tenant argued that because the schedule had been served under paragraph 8, and if we go back to paragraph 8, this is the one which provides for 3 months' notice. So the tenant said that because this has been referred to, it had to be served 3 months prior to the expiry for it to be valid. And because it was only served 2 weeks before the ish, it wasn't a valid notice. And the tenants relied on this to justify their failure to carry out the works. The tenants also had an alternative argument that there should be implied into the lease an obligation to give reasonable notice if the landlord wanted the tenant's alterations to be removed. And the first issue the court was asked to consider was whether the lease stipulates the landlord must provide at least 3 months' notice of dilapidations prior to its expiry. Lord Woolman looked at the view of a reasonable person with all of the background knowledge and concluded that the commercially sensible, there's those words again, interpretation of the lease was that the tenant was bound by its repair and maintenance obligations at all times without need for notice. If the condition falls below the required standard, the tenant's in breach, and those obligations don't have to be triggered by notice by the landlord, and anything different would have meant the landlord would have imposed a higher rent. And Lord Woolman put forward a number of reasons for his conclusion. Firstly, if the tenant was only bound to carry out works if served the notice and following an inspection by the landlord, this, in Lord Woolman's view, would undermine the scheme of the repairing obligations. Secondly, Lord Woolman said that each of the obligations should be read separately, and there's a distinction to be drawn between paragraph 8, which was the obligation to comply with repair notices, paragraph 3, which was the repairing obligation itself, and paragraph 28, which was the obligation to remove at expiry. And on this sort of separation analysis, the tenant's repairing obligations could not be conditional upon 3 months' notice. Paragraph 8 allowed the landlord to inspect and enforce the repairing obligation during the currency of the lease, but that obligation was separate from the obligation on the tenant to keep the premises in good and substantial repair and return them in that condition at the end of the lease. The tenants didn't have any success with their alternative argument that reasonableness must be implied into the lease either. Lord Woolman says that an implied term of reasonableness was incompatible with the express agreement in the licences for works, that the landlord could enforce the repairing obligations at termination without notice. One other question that Lord Woolman looked at was if the dilapidation schedule was actually itself a valid notice, and he relied on another dilapidations case, which is L. Batesley Pet Products against North Lanarkshire Council, and he concluded that the removal of the licensed works was not a process which landlords to serve notice. He said that if the tenant was in any doubt as to what they were being asked to do, they could have asked the landlord if they wanted the alterations to be removed or not. The lease terms in this case seem to suggest that reinstatement works could be carried out by the tenant after the lease had expired, and it may be the result would have been different if those terms hadn't been there. The case really confirms that in the absence of clear and express provision to the contrary, tenants will be under an ongoing obligation to comply with their repairing obligations during and at the end of the lease. And notice from a landlord is not required to trigger that repairing obligation. I don't think that the case is really that surprising. It kind of follows the trend that the courts are not willing to provide effect to a clause which results in a windfall for either party. So what practical tips can we take from this case then? I think there's 3 main things. The first one is that if parties want to agree that notice is required, they should ensure that such terms are clearly drafted. From a tenant's perspective, if the lease provides there to remove alterations or replace items, they should ask the landlord at the time that the NTQ is served if they require the items to be removed or replaced, to avoid a situation where the tenant is unclear as to what they're being asked to do. And lastly, from a landlord's perspective, they should check the lease. Also look at other documents, licenses for works in this case, quite carefully, and ensure they comply with any provisions about notice that are stipulated in the lease. And they should also communicate quite clearly with the tenant to avoid any ambiguities or uncertainties.
Okay, back to the topic of interpreting the repairing obligations and turning to the most recent of the court decisions we're looking at today. This is Acts Pension Trustees against Insight Travel Services, which is an inner house decision that was issued in December. Much like Mapley, there were 2 issues in this case. There was an issue around interpretation of the repairing obligations in question, and there was an issue over whether the landlord was entitled to the total costs in the scheduled dilapidations, again regardless of whether the works were going to be carried out, or whether the landlord's claim was restricted to damages for loss. Stephanie is going to look at that second issue in a moment. For now, I'm going to look at the issue around interpretation of the repairing obligations. The relevant wording is on the slide. Fairly standard wording in a full repairing and insuring lease, the sort of wording that's quite frequently found in leases of this nature. What the tenant argued in this case was that that wording did not require them to put the premises into a better condition than they were in at the commencement of the lease. Now, that argument was accepted by the judge at first instance. I mentioned earlier that the decision at first instance in ATSIP was issued in September 2014, very much in light of Grove and the judge applying the principles which the court discussed in Grove, and the tenant's argument was successful. The appeal court, however, took a very different view and rejected the tenant's argument. The appeal court concluded that this was not a case where there were two possible interpretations and that you needed to get into looking at which one best accorded with commercial common sense. The court concluded that the natural meaning of the words used was that the overriding and minimum repairing standard was good and substantial repair. If the condition of the premises at commencement was not good and substantial repair, then the tenant had to perform their obligation to repair and keep in good and substantial repair in such a way as to achieve that standard. What that meant was that the obligation to keep in good and substantial repair did carry with it an obligation to put into that state of repair. And the court did look at all of the wording that's used, and just pop back to the slide. I mean, what the court concluded, and certainly what the landlords had been arguing, was that if the tenant's interpretation was correct, then some of the words that were used in that clause would really be rendered meaningless. For example, the standard good and substantial repair, all to the satisfaction of the landlord, regardless of the age or state of dilapidation of the buildings. All of that, the landlord argued, would essentially be rendered meaningless if the tenant's interpretation was preferred, and the court agreed with that. So again, part of this shift that Stephanie is talking about, what this case represents is a shift back, I think, in favour of landlords' interpretations generally. Now, whilst much will very much turn on the specific wording that's used in a lease, certainly I think landlords' understanding would always be that sort of wording would incorporate an obligation to put items into a particular condition if they were not in that condition at commencement. And so what this decision has done, I think, is probably brought a little bit more predictability back into interpretation of repairing obligations from a landlord's perspective, certainly, than there was previously, although, as I say, much will depend on the precise wording in the lease, and I guess the crucial consideration is it a situation where the clause is ambiguous, is open to more than one interpretation? Now, in those circumstances, you do get into that analysis that was carried out in Grove and Mapley about what is the interpretation that best accords with commercial common sense. But otherwise, if there really is no ambiguity, then the court will give effect to the natural and ordinary meaning of the words used. Stephanie is now going to talk about the second issue in the case, which again, returning to this issue of whether the landlord was entitled to payment of the total cost of the schedule of dilapidations, or whether what the clause provided for was damages for loss.
Yeah, thanks, Anne. So we're back to payment versus damages, and the ATSIP provision is on the slide there. The relevant bit is in bold. The obligation was to pay to the landlord at the determination date a sum equal to the amount required to put the leaseholders back into good and substantial repair. The court concluded that the natural and ordinary meaning of this clause was that it was a payment clause and not a damages clause, meaning the sum due by the tenant did not depend on the loss suffered by the landlord. That was a different result to what we had in Grove. The court said the words clearly showed the parties intended that if the subjects were not at termination, the condition they should have been in, had the landlord complied with its repairing obligation, and the landlord is entitled to payment of a sum equal to the cost of bringing the premises up to that standard. The landlord's intention to carry out the works was, the court said, irrelevant. The fact that the cost of carrying out the works may have been disproportionately more than any increase in capital value of the premises achieved as a result was also, the court said, irrelevant. What about Grove? As Dan said, we've got a shift away from what the court said in Grove and a move back to where we were before the Grove case came out. The Inner House contrasted the wording used in ATSIP with the wording used in Grove and said the ATSIP provision contained a procedure we didn't actually see in the Grove provision, under which the landlord made an election and served notice on a tenant, which required the tenant to make the payment in lieu of carrying out the repairs, which the court found to be significant in suggesting the landlord's right was to a contractual payment as opposed to damages. Also, the court said the wording in Grove made reference to the landlord and tenants coming to a settlement based on the value of a dilap schedule, as opposed to making reference to the cost of making the repairs, which the court saw as being similar to a damages clause. Ultimately, the differentiating factor between ATSIP and Grove really was that the ATSIP wording was seen as including a landlord's right to demand a contractual payment which wasn't linked to loss, whereas the wording in Grove was not. The court in ATSIP set out some helpful pointers in relation to contractual interpretation, which follow what the Supreme Court said in Untitled against Britain, which we covered in the last webinar. The court was quite clear to say that care must be taken to avoid looking at anything said in Grove as being to the effect that the court can correct a bad bargain or even an unfair bargain, and there's no general rule that a commercial contract requires to be fair. It's also important to note, I think, that Grove did not lay down any general rule to the effect the landlord in a commercial lease is at termination, if there's outstanding repairs, only allowed to be compensated for capital loss actually suffered. But the correct question is really what the parties intended at the commencement of the lease. And the Scottish courts, in line with the Supreme Court, interpret what the contract actually says, as opposed to trying to find an ambiguity which would allow them to apply our old favourite commercial common sense. I think it's probably fair to say that everyone, maybe except Insight Travel, welcomed the decision in ATSIP. I've heard it said it's a case of the landlord strikes back, and for the landlord it's a welcome return to normality. Landlords can now recover large sums for dilapidations, regardless of whether the work is actually going to be done or not. And as Dan alluded to, the case does reverse the tenant-friendly trend that we saw emerging in the dilapidations cases in 2014 and into 2015, and is an important reminder for tenants that they should take advice at the outset as to the extent of their obligations and be absolutely clear what they're actually signing up to when they contract with a landlord. Taking expert advice when the lease terms are being drafted is crucial. When the lease is entered into, the amount of money at stake is often not obvious, but as we saw in Grove, which I think was 10 million, Dan, is that right? 10 million? And that's it, again, substantial sums involved. These sums at the end of the lease are often quite significant, and clear and proper drafting of the lease at the outset really does matter. Back to Dan to conclude.
Thanks, Stephanie. Now, if anyone has any questions, please do pop them into the chat facility, and we'll have time to answer one or two if you do have any. But I mean, just in terms of some concluding comments, where are we now? Well, after the decision in ATSIP in December, well, I think, you know, as I indicated earlier, I think from a landlord's perspective, it will have been a welcome decision, and in some ways, I guess, will have brought back a measure of certainty when it comes to interpreting repairing obligations, interpreting the tenant's obligations at termination in a lease. I suppose it also brings an element of certainty in that, as Stephanie mentioned, it was decided very much in the light of the Supreme Court decision in Arnold against Britain last year, and now this is Arnold against Britain was a decision that we did look at in our previous webinar, but we'll also be covering in the next webinar in the series, which will be looking at interpretation of property contracts and implication of terms. It's a significant decision in terms of how the court actually looks at giving effect to the wording used by the parties and the circumstances in which this principle of commercial common sense falls to be applied. And ACSIP was a decision that was very much decided in the light of Arnold against Britain, and indeed the court made that clear in the decision in ACSIP. Now, it's also important to make clear, as Stephanie has explained, and as the court highlighted in ACSIP, the wording in the lease in Grove differed from the wording in the lease in ACSIP, and that does, I think, largely account for the difference between the court's decisions. But the court also did point out that the observations made by the court in Grove in relation to interpretation of contracts did predate the guidance provided by the Supreme Court in Arnold against Britain, and that those observations must accordingly be regarded with what the court in ACSIP described as an appropriate degree of caution. So it's important to bear that in mind. Ultimately, so much will turn on the precise wording that's in the lease, and it will come down to this determination of whether the wording is so clear and that the ordinary and natural meaning of the words must be given effect to, regardless of whether the outcome might be seen as being fair for one or either of the parties, or whether there's genuine ambiguity, which means that the court then needs to get into this analysis and deciding what is the interpretation that best accords with commercial common sense. But Arnold against Britain, which, as I say, we'll be looking at in the next webinar in the series, is a very important decision in that regard, as is ACSIP. The next webinar, as I say, it's looking at interpretation of property contracts and implied terms, and that's on the 30th of March, and hope you can all join us from that. Now, we have had a question that's come through. If there's no right to payment in lieu of dilapidations in a lease, could one be implied? Well, I think the answer to that is no. I mean, I think and I don't think ACSIP has changed this. There really does, I think, need to be an express provision. If the landlord is going to be entitled to payment of the costs and a schedule of dilapidations, regardless of whether the works are going to be carried out, and that has to be clearly provided for in terms of the lease. We saw with Grove, with ACSIP at first instance, with Mapley, it was looking very much like that would have to be really spelled out absolutely clearly in words of one syllable if the landlord was ever going to be able to get that. Now, ACSIP on appeal, the landlord did manage to get that because the court decided that the words of the clause were clear enough to entitle the landlord to that. But essentially, no, that will need to be provided for in the lease. It's not something that can be implied, and in the absence of a provision like that, then it really is a question of falling back on the common law, and what the common law entitles the landlord to is damages for losses suffered as a result of the tenant failing to comply with their repairing obligations.
It comes with the point on drafting as well, that it's important, if you want that right to be in there when you're negotiating a new lease, make sure that is clearly specified when the lease is drafted and negotiated.
Indeed. Now, we've got one other query there. So, going forward, solicitors will now need to determine the measure of loss under the wording of the lease as to payment or damages, and surveyors will then be left to quantify that loss as quantification of dilapidations or diminution in value. Yes, I mean, that's broadly. I mean, I think the first step in terms of looking at the landlord's remedies, yeah, it will be a question of looking at the provisions of the lease, determining, do the provisions of the lease give a landlord an entitlement to payment? And if that's the case, then actually, you don't need to get into questions of, what are the landlord's intentions? Are they going to carry out these repairs or are they not? You don't even need to get into questions of diminution in value, because you have, if the clause entitles the landlord to payment, then it entitles the landlord to payment. But in the absence of that, then yes, you're looking very much at damages for loss, and as the courts have made clear in a number of decisions going back quite a long way, in Scotland, there's no fixed way of determining what the loss is. The standard approach remains that the loss is measured by reference to the cost of repairing and reinstating the premises, but that's not the only possible measure, and as the questioner has alluded to, diminution in value is a possible alternative, You know, that's something that the courts can look at in determining what the landlord's true loss is. Unlike in England, you know, where the landlord's claim is capped at the diminishing in value. We don't have that in Scotland, but that doesn't mean that a tenant can't come along and argue that, in fact, the landlord's true loss is represented by any a diminution in the capital value of the premises as at the date of expiry. So yeah, I mean, that's certainly something that can be looked at. Okay, well, thanks for those comments. We'll have to wrap it up now, unfortunately, but if anyone does have any further queries, please feel free to contact either myself or Stephanie. Happy to discuss any of these issues or answer any queries that anybody has. And I hope you can join us for the next webinar in the series, which is on the 30th of March. Thank you.